Next, if I can call on the Canadian Constitution Foundation.
Minister LeBlanc. My name is Sujit Choudhry. I'm counsel for the Canadian Constitution Foundation. So,
good evening.
Good evening. I'd like to pick up on a theme that was being developed by my friend from the government of Saskatchewan. And so the theme I would submit to you is this, that as you know, the Emergencies Act has a number of requirements that has to be met to declare a public order emergency, correct?
That's right.
And so it's one of the questions that we're trying to get at is whether at the first minister's meeting, the Prime Minister and other members of the cabinet in attendance effectively communicated to the first ministers why they felt those requirements had been met. So my friend just asked you questions about the availability of other legal options, the so-called policing plan, correct?
The policing plan, you're referring to the City of Ottawa policing plan?
Well, or what Commissioner Loki has put into evidence, that there was, in fact, by the 14th, a policing plan available or ready to be triggered. And my friend, I believe, asked you whether that plan was put to the first ministers and you weren't sure if it had been or not.
I'd want to see the document. One of the major concerns that the government had is the lack of effective policing plan, particularly in Ottawa, to some extent in Windsor. These things had dragged on now for 2 and 3 weeks, and the policing authorities were not advancing a plan, or more importantly, implementing a plan that would bring these to a conclusion. But the First Minister's meeting didn't discuss operational details of policing plans.
Well, what I'd like to do is pick up on another limb of the legal test for whether a public order emergency can be declared, which is whether there's a threat to national security. And you're aware of that, correct?
Yes.
And so you're aware that under Section 16 of the Emergencies Act, the Governor and Council can only declare a public order emergency if there's a threat to national security.
Yes, and we concluded there was.
You did. And did you provide any type of documentation or explanation to the first ministers as to the basis for your conclusion that there was a threat to national security?
Again, in terms of documentary evidence, or documentary exchanges, I wasn't privy to those. I do know that deputy ministers of public safety were sharing information, the commissioner of the RCMP, obviously, with various police leaders in other jurisdictions. So there was an ongoing and active exchange of information, as is entirely appropriate, between federal and provincial law enforcement officials. But in terms of whether that particular policing information was shared at the First Minister's table, it was not.
So, Minister, I'd put to you this, that for the consultation requirement to have some substance to it, the federal government is under a duty, I'd ask you, to be as transparent as possible with the First Ministers on that call about why it is taking the exceptional step of triggering the Emergencies Act, correct?
Why we were considering taking the exceptional step. And as I explained to your colleague, the Commission Counsel, those reflections, those considerations were informed by more than 3 weeks of active exchanges between the Government of Canada and provincial and territorial counterparts. So to say that they were not in possession of the intelligence information, the policing information, I don't think is an accurate description. And I know many of the premiers, because they told me, were also being briefed on an active and ongoing basis, in some cases by RCMP commanders in their particular provinces, because the divisional commanders of the RCMP are, of course, contract police in that jurisdiction, and they were having ongoing and active discussions with public safety ministers in those provinces. And in the case of Premier Kenney, he was clearly being updated in considerable detail by the police commanders in the province of Alberta.
Sure. But Minister LeBlanc, I believe you understand that at this point, according to the evidence that we've heard in the commission, there were two potential sorts of threat assessments at the center presented in the Privy Council office. The first, you're probably aware of, is Director Vigneault's assessment, correct? And he'd concluded there was no threat to national security for the purposes of the CSIS Act.
And
You're
that's
aware
a
of
very
that?
significant, yes, for the
yes.
purposes of the CSIS
Right.
Act. And I think it's important that there not be confusion around which particular section of what act he was referring to.
But as you probably know, last week, the NSIA, Ms. Thomas testified that in her view, there was a threat to national security under the Emergencies Act, correct?
Yes.
But was her view shared with the first ministers on that call, so that the consultation was more than just providing them with notice?
Well, I don't share your view that the consultation was providing them with notice. The National Security Advisor wasn't briefing the first ministers on that call. She would regularly update the cabinet and the incident response group. We benefited from her analysis and that of Director Vigneault as well. But I'm not quibbling with you. The purpose of that consultation was not to have a legal discussion with first ministers on the test that the governor and council was going to apply when and if we made the decision. My colleague David Lametti will be here tomorrow. He'll be able, I'm sure, to speak directly to the legal test that the government was using and concluded when the governor and council made the decision. We consulted carefully and listened very carefully to what first ministers said at that meeting and in a series of previous discussions in the preceding weeks as well.
But just to be clear, at the first ministers' meeting, you don't recall if a detailed threat assessment was provided to the premiers?
Again, first of all, that would not have been a secure forum. A telephone conference call is not normally where senior intelligence officials would share detailed threat assessments. So that particular venue would not have been possible or appropriate. But the way that information was shared with provinces and territories is through the ongoing and secure communications between law enforcement officials of the Government of Canada. And those premiers, many of them would talk to us about it, were being updated by their own deputy ministers of public safety or deputy solicitors general in some provinces, or senior police leadership in their province that had the benefit of an open exchange in a secure context with the Canadian intelligence and law enforcement officials that were briefing the Government of Canada.
Minister, I have a couple of minutes left. I want to take you to a different issue, if I may. It's about your conversations with the Government of Quebec and the reservations expressed by Premier Legault and then your subsequent phone call with Minister LeBlanc. And if I understood you correctly, it was your position that the economic emergency measures that were taken had to apply nationally, correct?
Oui, moi j'ai offert.
Yes, I told Minister LeBlanc after the discussion with the premiers that for the economic measures to be effective, they had to be applied nationally. Because if somebody had a bank account, for instance, at the Caisse Populaire in Quebec or at the National Bank, that would not be actually out of reach from the measures that we would take.
But the same rationale does not apply to the non-economic measures, does it?
Well, it does in the sense that they were preventative. We thought it was important, as I said to your colleague earlier, it wasn't clear that this problem was going to go away or that the people occupying the bridge in Windsor, Ontario weren't going to displace themselves somewhere else. There was an active discussion about risks to other critical infrastructure. So we thought that the national application of those measures, in the case it ultimately was necessary, would have given the local law enforcement authorities the tools, for example, that the City of Ottawa and the Ontario Provincial Police and the RCMP use so effectively to bring the occupation in Ottawa to a conclusion.
Mr. LeBlanc, let me end with this question then. But wouldn't it have been an alternative to have offered those non-economic measures to those provinces that wanted them, and to enable them to opt in as they wished to? So those provinces who needed and wanted those powers could have gotten them right away, and those that maybe needed them later could have opted in if they needed them.
That wasn't considered as a responsible or realistic option, because by enabling all of the local enforcement, law enforcement, and provincial police authorities to have recourse to those powers, should they, in their judgment, determine they were necessary, was a more effective and comprehensive way to provide the deterrent effect to not have a particular group of illegal occupiers in one spot displace themselves somewhere else. So we didn't think we should be having governor and council processes every day following that decision. The more effective and responsible way was to enable those authorities in the other jurisdictions to have recourse to that, should they, in their judgment, decide it was necessary.
Thank you, sir.
Thank you.